Good afternoon. My name is Jennifer Becker, and welcome to the Retirement Planning Workshop of the Month. I'm excited to be able to offer you these educational webinars monthly. I am the VP of Business Development here for FAIRWINDS Retirement Planning, and today in the room I have Brian Kent. He is our VP Financial Advisor and Sales Manager, also in Retirement Planning. And then today I am excited to be able to present or to introduce our speaker, Joe Procopo. He is a partner at Mateo Harbert, it's a full-service law firm located in downtown Orlando. And Joe's practice has a focus on estate planning issues. Joe is a graduate of Stetson College, FSU Law, and University of Florida Tax Program. And with that, I'd like to go ahead and turn the microphone over to Joe. Welcome, Joe.
All right. Well, thank you, Jennifer. Thank you, Brian. There's a section on your webinar where you can enter questions if you have them. And basically, we will see which ones we can tackle as we're going through live, but others we may wait to get to until the end. But please do send in your questions. We are going to be monitoring and tracking that. I've had the privilege of presenting for FAIRWINDS a few times before, so some of you may have attended prior estate planning type presentation. This presentation is new and it's different. It's geared more towards planning, whereas the other one was more explanation of what estate planning documents are. So with that, I'm going to get into this presentation.
Joe, I don't want to interrupt you. Oh, well, I do want to interrupt you really quick. We also have an outline that you're available to download, or we will make sure it's available to download. You should be able to see that on your screen and download what's called the Lady Bird Deed Outline. And it should be available for you to download during the presentation. After the presentation, we will also send out a replay link of the actual presentation. Thank you, Joe.
Yep, perfect. And I'm sure if you email Jennifer, she can send you copies if you're not able to access it of the outline or even the slides. So this presentation is titled Lady Bird Deed, an Inexpensive Probate Avoidance Technique. So besides saying, the name Lady Bird Deed as being fun, it does have a very useful purpose in the estate planning world. However, not largely known. But before we get into that, the first thing we have to talk about is, what is probate? Why is it necessary? And when is it necessary? So, probate is going to be the legal process which assets that were in a deceased individual's name and ownership are transferred to beneficiaries, either through a will, trust, intestate, those getting it to the new owner. Now, when is a probate necessary? It's really one of those, regardless of value of the estate, if an individual passes away and has an asset in their name only, then that's going to require probate. And a great example is if you've got an account here with FAIRWINDS that has $10,000 in it and you pass away, we have to open up a probate, even though it's only a total of $10,000, to get that where it needs to go. So the purpose behind today's conversation is, what are methods to avoid having to go through probate? Because probate, I generally tell clients, can run anywhere from $2,500 to $5,000, $6,000, $7,000, depending on the complexity and the situation. So as part of our planning, when we're reviewing this, we're often looking for, okay, what are ways we can avoid probate? And that's really what we're going to get into before I dive into the Lady Bird Deed. The traditional methods that you see, starting with beneficiary designations. And let me preface this by saying this is the most costly mistake I see when folks don't check on this, even if they think they've done it right, and double check it to make sure it is right. The reason this is so important is because whoever you have designated as a beneficiary, when you pass, that asset is going to go to that person or persons. There's not going to be a probate. You're not going to have to wait around for a judge to approve it. It will pass. Now, the type of accounts that you traditionally see here are things like your qualified retirement accounts, IRAs, 401ks, life insurance, annuities, 529 plans, and I'm sure most of you are familiar with those. One other type is called pay on death or transfer on death designations. And this is something that financial institutions will offer, that you can name on your bank account a beneficiary. So going back to the earlier example, you have that $10,000 account and you name your son. If you pass away, that goes right to your son, no probate. We don't have to spend $2,500 to get 10. So it's very important, and it has to be done correctly for this to work. This is a great area where you can look to your FAIRWINDS advisors, because they're going to be familiar with their forms, what needs to be filled out, and they can help you fill out and get this stuff all updated so that you can hopefully avoid probate. The next item is the use of trusts. And I'm just going to mention this briefly. Trusts can be a great tool. Their primary purpose is going to be probate avoidance. So if I have that bank account in my name, it goes through probate if I didn't have a beneficiary. But if I take that bank account and put it into my revocable living trust, now if I die, the trust owns it, not me, no probate. So the trust is a very easy tool to use to avoid probate. However, it's a lot more complicated. It has a higher cost to put together, and then there are steps that you have to take for it to be effective. And most importantly is, with the trust, you have to do what's called funding it. And that means you actually change the title of assets into the name of the trust. It's not simply where you have a written statement that says, I give all my assets to the trust. That doesn't work. Bank accounts in particular have to be retitled. Again, this is another area where your advisors here at FAIRWINDS can give you a hand to make sure that it's done correctly. Other items where you'll see this is real property. So if you've got a rental, that needs a deed to actually get it in there. Business interests, if you have an LLC or partnership, anything like that, you need to assign it to the trust. And then there's also personal property that can be assigned to the trust. The area where I would generally will recommend a trust is especially if someone has real property located outside of Florida as well as in Florida. And the quick reason for that is, with real property, wherever it's located, you have to do a probate. So potentially, if you have real property in Florida and Georgia, that's 2 probates, and your probate cost doubles. So having a trust, you can put the Georgia property in the trust and even the Florida property in the trust, and it avoids probate. So the next item is going to be joint ownership. And there's a few different ways that assets can be owned in general. The first is what's called tenants in common. That's really not useful here. It's a type of ownership where you and someone else own a percentage and your estate controls where that goes for purposes of probate. So the ones that are important to us here during this presentation are joint tenants with right of survivorship and tenants by the entirety. It is important, and a lot of clients don't realize that when they create a joint tenants by the entirety account, or excuse me, a joint tenants right of survivorship account, they may name one child to be on their account with them. Well, unbeknownst to them, if they pass, that account actually only goes to that one child. Now, he's not obligated legally to share it with his siblings or anyone else. So, I see that often for convenience. Kids are added, and you just want to be careful because it can impact what you thought was going to happen. The other one, tenants by the entirety. So joint tenants right of survivorship is good for anyone. Tenants by the entirety, though, is one that only applies for a married couple. So you have to be married. After you're married, you open up accounts together. It's tenants by the entirety. The reason that operates to avoid probate, in that if one spouse dies, it automatically passes to the surviving spouse by operation of law. So that's very useful, and it also comes with a creditor protection benefit that assets you and your spouse own jointly are not subject to your individual creditors. So say one of you is in a car accident and gets sued, it shouldn't affect what you jointly own. Now, the exception, and I'll just touch on this real quick, is cars, automobiles. Do not own those jointly. If you have your children's names on any of your automobiles, make sure your name is not on it if they're the driver. And the simple reason for that is Florida has a dangerous instrumentality law that basically says whoever owns the vehicle is responsible for it if there's any damage done. So that is one where it doesn't affect your insurance, so you can all be on a family plan, not a problem, but just make sure your name is not, the primary driver is the only name on the title. The exception would be 16 and 17-year-olds because those, someone has to have authorized them to have a license, and in that authorization, you're agreeing to be liable. So there's no getting out of it. But the day a child turns 18, you want to get the title just in their name. All right, so the next item is what's called a life estate. This is the traditional style, and the Ladybird deed, which we'll be getting to shortly, is a take from this. But to better understand the benefits of the Ladybird deed, I want to make sure everyone has an understanding of how the regular life estate works. Essentially here, we're dealing with two groups of people. We have what are called life tenants, and we have those that are remaindermen. And it's almost as the name implies, the life tenants are the people that are currently in possession of the property. The remaindermen are the people that are set to take the property upon death. It avoids probate in the way it's titled, that when the life tenant passes, title passes automatically to those remaindermen. So that's where the probate avoidance benefit comes in. A big thing here, though, is when you do a traditional life estate deed and you sign it and you record it, it's a completed gift. That is done. And once you have done that, the individuals you've named as remaindermen now have certain rights in the property. So as the life tenant, you still maintain full use and possession, but you're responsible for general repairs, upkeep, HOA, insurance, interest payments as the life tenant. You're responsible if you commit what's called waste. That could be, removal of timber, crops, destruction of property. That can be charged against your interest. But what's nice is, as a life tenant, you could rent the home out and you can keep all of the profits from that. That can go on as long as you're alive. But upon death, that's it. The property passes to the remainderman. It doesn't go through your estate. So even if you had a will that says, give that property to my son John, if you had a remainderman naming someone else, that is where it's going to go. Now, the remaindermen have no right of possession until the life tenant dies. However, the remaindermen do have responsibilities in this, in that principal payments on loans against the asset, extraordinary expenses. So if there was hurricane damage, for instance, that's an expense that the remaindermen have to deal with. The remainder interest can also be set up as joint tenants right of survivorship, tenants by the entirety in doing the deed, that it can be done that way as well. With regards to the remainder interest, a remainderman can convey it before the life tenant has died, so they can transfer their interest to someone else. However, the person who receives that interest doesn't get it until the life tenant dies. A big thing to point out within a traditional life estate is if you want to sell it. So mom and dad put their kids on as remaindermen. Now they want to sell the house. You can't sell it unless the children also sign off on it. So you give up a significant amount of control that you otherwise unilaterally had by having the asset in your name. Homestead, I want to touch on with this. Some of you may be aware, for those that aren't, Florida has certain restrictions as to how homestead property can pass if you're survived by a spouse or a minor child. So if you have a house in your name and you want to leave it to your best friend, but you have a spouse or minor child, you can't do that. And that's in the Florida Constitution. Now, if you use a life interest, creating a life estate, that, because the deed is designed to transfer on death, avoids the homestead devised restrictions. So in that case, you could leave it to a friend even if you have a surviving spouse or minor child. Now, granted, if you have a spouse, they have to consent to any new deeds that are related to the homestead. The life tenant gets to maintain their homestead exemptions. I'm sure many of you are familiar with those. There's creditor protection benefits, there's tax exemption benefits. Those all get maintained. However, the remaindermen cannot claim homestead until they take possession of the property. And that's at the life tenant's death. And that includes even if a life tenant allows the remainderman to be living in the house, they're unable to claim homestead. And when the life tenant dies, it's what's called a reassessment event, and taxes kind of get reset at that point. And if there was a creditor, they potentially could wedge themselves in there in between. Once the remainderman takes over, they can apply for their own homestead at that point and then get those benefits and protections. So that really takes care of where we're at with the traditional life estate. And now I want to get into the ladybird deed. Now, this name is believed to have originated from a professor's example where he used Ladybird Johnson in this special type of deed. The actual technical name for this deed is called an enhanced life estate deed. This is not permitted specifically by Florida statute. It is permitted. We have a Florida Supreme Court case back in 1917 and another in 1942, which authorized this type of deed. But because there's no statute, that also means we don't have specific language for it.
Joe, can I ask you a quick question?
Absolutely.
I apologize. Could a trust be a remainderman?
Great question. Could a trust be a remainderman? Yes. An instance where I will do that is, let's say I have a client who has a trust and they have homestead. To avoid any of these conflicts, I might name the remainderman as the trust. So this way I still own it, no problems, but when I die, I know it goes into my trust, and then my trust says where it goes. But again, it has to be done correctly, otherwise you could trigger one of those devise restrictions. The devise restrictions aren't there with the traditional life estate, but as we're getting into the ladybird deed, you'll understand that they are applicable here. So because there's no specific statutory language for us to go on, it means the language you see in a ladybird deed, any ladybird deed, has been a product of the creative drafting of that individual. Not all states allow it. It's also very much unknown to folks here in Florida. But the biggest benefit of the ladybird deed is we get a lot of the good that's in the traditional life estate, but have a reservation of powers and retain certain rights. So generally, in a ladybird deed, you'll include a reservation to be able to sell it, rent it, mortgage it, bulldoze it, gift it away, anything. And as long as you have spelled it out in the deed properly, it's a permissible power that you retain as the creator of that deed. So it's set with this specific language, so you can do whatever you want essentially with the property while you're alive, but we get that same kind of traditional life estate benefit that upon death, if you still own the property, it's going to pass outside of probate. And, that's one less thing that we have to worry about. The big thing with the reservation of rights language is, that's important, is reserving the rights to divest the remainderman. And this is getting a little technical, and not that any of you have to know this yourselves, but if you see it in a deed, that's why, is you want to specifically say, hey, if I want to give this property away, I don't need the consent from those remaindermen I was otherwise going to leave it to. So it is critical, though, that the deed is drafted properly. If it is not, that can cause problems. Now, let's say you've done a ladybird deed, you named your kids as the remaindermen, and now, you want to take them off of it and give it to your favorite charity. And the kids say, we're not signing. In a traditional life estate, you're stuck. In a ladybird deed, you have technically, drafted properly, reserved the right to give that away even without those remaindermen consents. When we do that, there is a recommended kind of special type of deed that I refer to as a divestment deed. And it's similar to most deeds that are out there, but it includes basically an extra paragraph tying back to the original deed and the powers to get it out. What is great about that is you don't need their consent. So in that hypothetical, You could obviously go to your kids and say, hey, can you sign off on this, and not worry about it. But if you don't want them to know that you have changed it or removed them or added more people, then this is a way where you can transfer the deed without running into that issue. The way we would typically do something like that is if you had a life estate or the ladybird deed and you want to make a change, we would do two deeds. The first deed would be the divestment deed, where you take the property and give it back to yourself as the 100% owner. And then the second deed would be the new, presumably ladybird deed, naming the new people you want and record them. We do that so that there's a clean chain of title and that you can clearly see how it's all linked together. Homestead with the ladybird deed does operate differently. So you still get the benefit of the creditor protection, and you have the tax exemptions as the life tenant in the ladybird deed, the grantor. But because a ladybird deed is considered an incomplete gift, because it's not complete until you die, because you reserve the right to give it away to someone else. The traditional life estate was complete when you made it. So that's why the traditional life estate doesn't get subject to those devised restrictions. The ladybird deed does. Because it's incomplete, if you have a spouse or minor child, then it cannot pass via the ladybird deed. It passes by operation of law based on Florida's Constitution and the applicable Florida statutes.
I have a question for you.
Yes.
Under Florida law, is the home and auto protected by creditors?
Okay, yes. So a huge benefit to being in Florida and a Florida resident is it is creditor protected. Now, you do want to take steps to declare homestead. Usually that's done through the property appraiser's office, and that's also what's going to get you your tax benefit. But the homestead is creditor protected. So if you had a personal lawsuit against you and your spouse, even though you have this joint house, creditors can't take it. And there's also not a value limitation either on that. So you can have a very expensive house and owe a whole lot of money to creditors that are unsecured, and they can't touch it. So let's see. All right. The benefits of the ladybird deed. All of the costs and expenses we talked about earlier with the regular life estate, well, there, the life tenant has some responsibilities, but the remaindermen are also involved and have responsibilities and potential costs that they need to pay. Well, because this is an incomplete gift, the life tenant is responsible for all the costs. And that's also good because it means if something bad happens on the property and there's a lawsuit, that the remaindermen aren't responsible for it. So that, in my opinion, is a benefit that, especially in the estate planning sense, when you're looking to just want to use this to transfer an asset upon death, well, this lets you maintain your complete control. You pay for everything, but upon death, it will still avoid probate, and that will pass automatically. There's also, when you do this new ladybird deed and you record it, it doesn't cause you to lose homestead. You still maintain all your exemptions. There's not a reassessment event of any type. I will say, if you do record a ladybird deed, you may get a notice from the property appraiser's office asking you to recertify your homestead. That's okay. You just want to make sure it's clear on that it was your homestead before and it's your homestead now, and there has not been any sort of change in ownership. And not, depending on where you're located, not all property appraisers will send that, but if you do get one, don't get upset that you think you've somehow lost your exemption. As I stated before, there's no liability to the remaindermen, so they're not stuck paying for hurricane damage or slip and falls. The biggest benefit, is obviously the probate avoidance piece, but that you get to maintain control. So you're in charge of this asset as long as you're alive. And this works even for a married couple. It can be set up where there's two spouses, and they are the life tenants. And until both spouses die, any one spouse, that's surviving can still transfer the property away. Only upon the death of both spouses, provided there was no transfer, would it pass, and that avoids probate. So it's a huge tool in being able to maintain that control and really be able to deal with where you want that house to go. And the Ladybird deed, also, let me just clarify, is not only something that can be used for homestead property. This works for any type of real property here in Florida. Another big benefit is what's called a step up in basis. And this is getting a little technical on the tax side, but an easy illustration is I buy a house for $10. It goes up to $100 in value. If I sell that house, I had $90 in gains, and I'm going to be subject to capital gains tax. If I give my house to my kids, well, I paid 10, I gave it to my kids, they get it with a $10 basis just like I had, and they would pay $90 in capital gains. Contrast that with having the property where you've retained ownership until death, and then it passes to children. Under our current tax code, that same property gets stepped up to fair market value, and the children or whoever, the recipients, get it as though they paid that fair market value. So in that same example, you bought it for 10, it's worth 100, you die owning it, and it's going to your kids. Well, your kids get it as though they paid 100 for it. So if they sold it the next day, $100 is what they make, $100 is their basis, they have $0 that's subject to tax. So there is a huge income tax benefit that is out there that you risk losing when you make transfers during your lifetime. Now, there are other circumstances that outweigh that tax benefit and reasons why you might make a current lifetime transfer, but it's just important you know this going into it. For those of you who've bought real property, you've seen one of those line items being the documentary stamp tax that's applied based on the amount of your mortgage. Well, a Ladybird deed, even though you're recording a new deed, does not trigger that. There's no doc stamps on the transfer because, again, it's incomplete. Let's see. This last point, DCF does not consider the creation of a Ladybird deed to be a transfer of asset. And DCF is the Department of Children and Families. And where this comes into play is when you have someone who's receiving government benefits. The most common example is Medicaid. If a Medicaid recipient gives their homestead to their kids, well, DCF will say, you just gave away that asset, so we're going to disqualify you from Medicaid equal to the value of that asset, which is awful. And it's unfortunate. I have had people come in who have done that after the fact, wondering why they've lost Medicaid, and it's not easy to get that back. With the Ladybird deed, DCF, because it's incomplete and you haven't made a transfer, they won't look at it as a transfer of an asset, which means it won't count against you. So the great thing here is you can do a Ladybird deed, leaving it to your kids, get Medicaid, and when you pass, the house will transfer automatically to the kids. And the kids don't have to open up a probate. This becomes important because Medicaid, in certain instances, does have rights of recovery against the property. With the Ladybird deed, it's passing automatically by operation of law. And if there's no probate, there's really not a forum for Medicaid to go after the asset. They would have to spend time, money, and resources on their own to open a probate and try to get that pulled back in. And to date, I've never seen that occur. Doesn't mean they couldn't try it, but it's very uncommon. And lastly, like all good things, there are some drawbacks. And to me, the drawbacks, it's important that you're aware of and know they're there, but I still think the Ladybird deed has a place in estate planning and can be a great tool. So, the first drawback goes back to what I was saying earlier about it has to be drafted properly. You've got to have the right language. And a very simple illustration of that, if I have in my Ladybird deed the power to sell and convey, and that's it, and instead I just want to give it to my son. Well, the Ladybird deed did not say there's a power to gift. Sell, convey, yes, not gift. And that would not be a valid transfer. You wouldn't be able to do it without consent of the remainderment. So, that is a drawback. It's got to be done right for it to work the way it's intended. Otherwise, it's going to have unanticipated consequences and can throw what estate plan you thought you had in place off. The next area where we see potential issues are with lenders. So for instance, you've done a ladybird deed, you've got yourself, you named your children, and you want to take a mortgage against the house. Well, lenders are sometimes apprehensive of that because there is an argument to be made that they lent you the money knowing that this property transfers automatically on death. And banks don't want that kind of risk if they're providing a mortgage on the house. So, drawback, you could have issues dealing with the bank. However, this issue in particular can be dealt with. What I said earlier about doing a new deed where you transfer it from your current ownership to just yourself individually, you can do that. So you've reconveyed it. Now you're the 100% owner. You can go to the bank. You can borrow against the house. The mortgage becomes a secured interest. So even if you do a ladybird deed after the fact, it doesn't affect the bank's ability to collect and have that asset available if for some reason there were any non-payments. Now, this is one that I have seen before, this next one about title companies. And you have to understand that title companies are independent businesses and they have to manage, what business risk they want to take on. So despite the fact that we have this Florida Supreme Court case saying we can do this, and despite the fact that you have language that says, I can reconvey this without permission from those remaindermen, some title companies will still say, no, we see that, but we want the remaindermen to sign on this deed. And there could be a host of reasons why you don't want to have to go down that road. Obviously, if everything's good, everyone's cooperating, sure, you don't have to have a battle. But if you have reasons that you don't want to go down that route, well, this could be an issue. What I tell clients is to shop around. Because title companies are independent businesses, they have their own risk evaluation standards. So while one company might say, well, yeah, we read the deed, but we still want to have those remaindermen sign, another title company may read that and say, okay, yeah, you have the power right here. You properly reserved it and exercised it. We can provide title insurance. So don't feel as though you're captive if the first title company says, we want the remaindermen to sign. The last drawback, in my opinion, is the homestead devise and descent rules. Because the ladybird deed is an incomplete gift, it's subject to those rules that we went over earlier in the presentation. So for individuals that have, a minor or a spouse and they want to alter where that house goes when they die, that's where the ladybird deed is not going to be the tool for that. And we have to look towards other methods to make sure we can accomplish it. So those are the principal drawbacks that I've come up with and that I'm aware of. So with that concludes the material part of the presentation for today. And now I think we're opening it up to questions and tackle what we've got.
Thanks, Joe. Yeah, that was a really awesome presentation with a lot of really good information. We have a couple of questions in the queue. Feel free to open this up and ask any questions that you have. The first one is, should the title for an automobile have both names on it for a married couple?
Okay. The answer is no. Most married couples will get a car, they'll put both names on it, thinking, well, if I die, then my spouse owns it and there's no issues. However, by doing that, by having both names on it, if that car is involved in an accident, the person who's injured can sue both of you. And if they can sue both of you, those joint assets you have are potentially exposed. Now, homestead, as we said earlier, is exempt, so that wouldn't be, but your general banking account, certain investment accounts could be exposed because you had both names on the title. So I always recommend to clients when we're meeting and going through their assets, retitling the cars. Whoever is the primary driver of the automobile, it should be just in their name. Now, of course, you're going to use each other's vehicles. That's going to happen. But what you're doing is you're minimizing the risk. And it, as I said earlier, it doesn't affect insurance, so you can still have a plan that you guys are both on. It's merely how the car is titled that can create that liability.
Excellent. The next question that we have is a follow-up to a question that was asked earlier. And it says, in addition, what is considered secure creditor? Is it something like hospital bills or student loans?
So a traditional secured creditor is someone who has lent assets and they've retained an interest in something. So a mortgage. The bank lends you money for your house. They take back a security interest in the underlying real property. An automobile loan, the security interest in the actual car that a lender will take back. A hospital bill by itself is not, I will say with regards to hospital bills, this is important, that when you go into the hospital, be aware of what you're signing. I know it's hard sometimes to think if you're there, especially in an emergency situation, but you bring a spouse, loved one, mom, dad in, and they're dropping paperwork in front of you and you're signing stuff, you may inadvertently sign agreeing to be liable for any of the medical bills. So you just have to be very careful in the hospital setting with that one.
All right. Joe, in lieu of engaging an attorney, what is the best way to acquire or implement a ladybird deed?
So, you know what? I'm not recommending you do this. You can Google it and you might find some out there, but I know we didn't talk about what kind of costs you can expect. Usually a ladybird deed, you may pay an attorney between, $300, $400, $500. And that includes, a recording cost of about $20. So I would say if you're trying to avoid probate, that's going to save you thousands of dollars. It's worth spending a few hundred to know you've got the right language and it's done correctly. It's just with deeds, that's just not an area you want to mess up. But you do not need an attorney to prepare and record a deed. So let me be clear, you could do it on your own, but you take on those risks yourself.
Excellent. Joe, our next question is, how does the ladybird deed help if I have multiple homes, but the second one does not have homestead?
So the ladybird deed does not apply only to homestead. It's all real property. So let's say you've got 2 houses and for convenience, 2 kids. You want each child to receive 100% of the house respectively. So you don't want them to own both houses 50-50 together. Well, you could use a ladybird deed for your homestead that says when I die, it goes to my son, Johnny. And then your second property can say when I die, this property goes to my daughter, Sally. So even though that second property isn't homestead, the ladybird deed will still cause that to avoid probate and go, and that's hypothetical, to your daughter.
Perfect. All right. The next question is for autos. If one spouse has more assets than the other, should you title both cars in the spouse with the lesser of the assets? I believe this is a follow-up to the previous question.
Sure. No, you don't want to do that because let's say, wife's got all the assets, husband doesn't have any assets, and you put both cars in husband's name, right? But wife is driving that car. Well, now if there's an accident, they can sue husband because his name was on the car, but they can sue you, the wife, because you were the driver. So regardless of the assets that are owned by, a spouse, for cars, you want the primary driver is the only name you want on that title.
Perfect. All right. Our next question is, if I have a child that is special needs, is a trust or a ladybird better to protect them?
So, special needs trusts are a little bit different than what we're dealing with here. And I would say it really depends. So there's special needs where individuals just have physical challenges, but otherwise have full capacity mentally. And for those, a ladybird deed can still work just fine. You have to be careful. If you do have someone who's on government benefits, if you leave them assets, you could push them over limitations that the government provides to get those benefits. So that's one thing you have to be careful anytime you're dealing with special needs. But the other thing is if you have someone who has special needs that are about mental capacity, using a special needs trust enables that child or person to maintain their benefits with a separate pot of money that can be used for other things. Because Medicaid, for example, is not, a primary option. It's usually an option of last resort. So you're getting the bare basics with that. That's not dealing with haircuts, getting your nails done, taking a trip to the movies. All of those things are not coming out and being paid by Medicaid. That special needs trust that you've directed assets into for a child or friend or whoever will be able to allow that special needs individual to use those benefits without causing any sort of loss in eligibility. And, the special needs trust is something you can set up today. You can have it set up where it comes into existence when you die, but you don't have to fund it until death. So that can be put in place. And a lot of estate planning attorneys, if they're not comfortable with special needs situations, they'll send you to attorneys that do have a focus on it. But others, we can prepare documents that have special needs trust built into them, so it's there if we need it in that particular case.
All right, Joe, the next question, it's a little bit more personal, but they have asked that it could be spoken to generally. My husband was in a car accident last August. The vehicle was in my name, my house is homesteaded, and a business property is partially in my name. Am I exposed on the business property that is in a business name?
So, Jennifer, can you clarify how was the car owned that was in the accident?
Car was in the wife's name.
Okay.
And the husband had the accident.
And she also made a comment here that the home is registered as a homestead.
Okay. So because in this case, husband had a car accident, if a lawsuit was filed, they can sue you because your name was on the title. So then it comes down to what assets are exposed. Florida has certain assets that are exempt under the law. Your homestead being one of them, qualified retirement accounts, IRAs, 401ks, wages for the primary household owner have some form of protection. So it doesn't mean all of your assets are exposed, but you certainly have some exposure risk there. If you and your husband have a joint bank account, that's not creditor protected under Florida statutes. A creditor could garnish it, take everything that's in that account. The business interest is not going to be a protected asset. So a creditor potentially could get at your business interest. And I say potentially because there's some other factors involved there in determining like what exactly is that interest? Is it a partnership? Is it an LLC? Is it a corporation? Because certain types of entities have additional protections that may work in what's called kind of a quasi-creditor protection manner. And if you email Jennifer, one of the prior presentations that I've done before is on asset protection planning, and there was a handout for that. And Jennifer can certainly email that over to you, and that'll give you an outline of what assets are exempt under Florida law. If you do have a lawsuit, though, filed against you, I would recommend consulting with an attorney to discuss it, because there are methods to how you should approach that. And there are things you definitely shouldn't do that can create a lot more problems for you. And there are things that you can start doing to better protect yourself. But this is not something where I get this call all the time. We had a car accident. It's usually, Joe, I want to do creditor protection planning. Okay, sure. Why? Well, we were in a car accident last week and I want to make sure my assets are protected. At that point, because you have a known or potentially known creditor, if you take your assets and put them anywhere else, that can be unwound. And there's other penalties that could come in. It could, besides the cost of litigation, you give all your assets to your son. Now your son gets sued by this person to take those assets back, and they've got to defend the lawsuit too. So you have to be very careful there.
Excellent, Joe. Our next question is, if my elderly surviving mother goes into a nursing home and has a ladybug deed, how would that work with her Medicare?
So there's a distinction between Medicare and Medicaid. Medicare is insurance, health insurance, essentially, for older individuals. So the ladybird deed should have no effect on Medicare. Medicaid is a program that requires you to have under a certain amount of assets and under a certain amount of monthly income. So if your parent has a homestead, that's an asset, but it's an exempt asset. So regardless of how much, well, I believe there are some caps on the value, but it's fairly high. That is exempt, and Medicaid won't look at that homestead as an asset. And the fact that generally what we do there is we apply for Medicaid. Once we're on Medicaid, and we had the house, it was just owned in our parents' name, 100%. We get Medicaid, then we'll record the Ladybird deed so that it transfers it upon the death of our parent. And that takes it out of the probate system, and it makes it a lot harder for Medicaid to come after later on, but it doesn't cause any current ineligibility today.
All right. Our next question is, I have a special situation in regards to a property I purchased with my father. He and I purchased a house. He has since got married. In the event he passes, what happens to my property? What estate planning should I consider?
So the starting point is to look at the deed. How is it set up? If the deed you and your father signed is a survivorship deed that says, me and my dad joint tenants with rights of survivorship, well, then if your dad passes away, because you have it titled that way, you would get the asset. It wouldn't go to his new spouse. Other ways that it can be dealt with, like for example, if dad's living there using it as homestead and you have just what's called a tenants in common deed, just as you and dad are joint owners without any special language, well, then you have to take some additional steps. And that might be doing one of these other types of deeds. But in that case, now that he's married, spousal consent is required for any deed concerning homestead. So if it's dad's vacation property, he could transfer that to you or, no issues. But if it's the homestead, then we need spousal consent. This can be dealt with in a couple ways. There's special homestead type deeds that under recent Florida statutes that if drafted, you can get waivers. The other way is through things like prenuptial and postnuptial agreements. A lot of people hear that and they say, no, I don't want to do that and put my spouse in this predicament where they get nothing. But that's a misnomer. A prenup or postnuptial agreement can be as broad or as specific as you like. So your dad could have, with his new wife, signed a nuptial agreement saying basically it only applies to this property that you guys bought together, where everyone's made aware, new spouse is made aware of it. She agrees that it can pass however dad wants it to pass and that she disclaims any and all rights she may have in it. So it's not that dad has to go to new wife with this, hey, I want you to sign this nuptial where you're going to get nothing if I die, to this is just to protect my daughter, my son, that it goes to them upon my death. So it's a lot easier to have that kind of conversation.
Joe, the next question. Can a life estate deed be created when there is an existing mortgage?
So that's a very good question. And there's two parts to the answer. Yes, it can, but you have to look to your lenders. It's not uncommon that your mortgage documents have what's called an acceleration clause. And that may say, if you transfer this property without our consent, we can call the note due in full today. Now, generally with a Ladybird deed, that shouldn't be an issue because it's an incomplete gift. But if you want to be cautious, you can always call your lender and talk to them to find out.
All right, Joe, it looks like this is our final question of the day. Does a land trust also avoid probate and give the property to the beneficiary?
Yes, a land trust would do that. Usually when you see a land trust being used, it's because someone doesn't want their name in the public records as the owner. But it is a trust, which is a big contract, and that can specify when you die where that goes. So the actual land trust company that's serving as trustee, they have what's called legal ownership, but you have beneficial ownership still. So you can direct, upon my death, it goes to Johnny and Susie. Well, then that trustee is going to follow those directions if you die and you still have that property.
All right, well, that was the last question, Joe. We want to thank you so much for all this great information today. It's always a pleasure to have you. It's always a reminder every time that you talk about the auto titling. My daughter is now 19. I heard this when she was 18, and I still have not changed the title. So it's a great reminder to do things like that. So thank you so much today, Joe, for your great presentation. I want to thank the audience for all their good questions. And I also want to let you know that I will be emailing out the replay copy from my work FAIRWINDS email, which is J as in Jennifer, Becker at fairwinds.org. So you will receive the replay from me, and then you can reply if you would like the additional asset protection handout. Hopefully we will be able to have Joe come back at some point and do the asset protection webinar for you as well. And I also want to remind you that we have 8 financial advisors here at FAIRWINDS Credit Union that are located in all of the branches that we have here in Central Florida. They can meet with you to discuss change of beneficiary and help with changing titles and things on your different assets, your financial assets. So we do have financial advisors here at FAIRWINDS Credit Union, and we will also be sending Joe's information out to you as well if you need to contact him at a later date or his office for any estate planning work. So again, thank you guys so much. And with that, I am signing off. Have a great afternoon.